My name is Gary Altman. I'm an estate planning attorney, and I'm going to talk to you today about the potential tax changes that are happening in Congress. Currently, the estate tax exemption level is $11.7 million for each individual, which means that if someone dies and their assets are less than that amount, there's no estate tax. If they die and their assets are more than their amount, there is estate tax. And at this level, it doesn't affect many people. But Congress is considering lowering that exemption to either $3.5 million or about $6 million, which means many, many more people will be affected by the estate tax when they die. The estate tax rate is 40% currently, which it would be. So that means if your assets were worth $10 million and you die and the exemption level was $6 million, your kids would pay 40% of $4 million or $1.6 million. In order to preserve the current exemption, what clients are doing today is giving away their current exemption. So if they have $11 million, they're giving that away into some sort of trust that will benefit their kids, maybe themselves, and maybe their spouse. If we give it away today, then we've preserved the exemption level, even if Congress lowers the exemption level, which means you would be saving, or your heirs would be saving $1.6 million or more. Currently, if someone dies and they had bought Microsoft stock at $1 and now it's worth $100, when they die and their heirs sell the stock, they only pay capital gains tax on if it's over $100 a share. That's a really good tax savings for most American families. Congress is considering eliminating that concept of a stepped-up basis, and they're even considering more than that. They're considering saying that when you transfer or gift assets to a child, there will be a capital gains tax at that point. Moreover, they're considering that when you die, let's say you had that Microsoft stock and it was worth $1 million and you paid $100,000 for it. But Congress is considering is saying that when you die, even if your heirs don't sell the stock, they're going to pay capital gains tax on the difference from what you paid for it and what it's currently worth. What a planning step people can do now is to give the assets away now before they die, before Congress changes the law, so that there will not be this deemed tax at death. A couple of the changes that Congress is considering is eliminating what is referred to as valuation discounts. Suppose you own a business with your best friend, and you both have equal control over that business. Well, if you were to sell your business interest to a third party, no one's going to pay you your share of the business. So let's say the share of the business, if you or your friend sold it, was worth $10 million. If you sold your half to another individual, they're not going to pay you $5 million because they don't have control over the business. So that's called a valuation discount. And that's a very powerful tool when we're considering transferring business interests or real estate interests to the next generation. Well, Congress is considering eliminating that. So what clients are doing right now is giving those interests away now, getting this called valuation discount so they can give more to their family without imposition of a tax. Two other changes they're considering are a little more esoteric. One is stating that if a trust which you created is still going to be taxed to you for income tax purposes, then when you die, that trust is includable in your estate, even though the assets would not otherwise be includable in your estate. That's really hard for people to understand and mean. So let me give you an example. I created a trust for my kids. I put assets in that trust for my kids. There was no tax when I put assets in trust for my kids because it was lower than the amount that passed free of gift or estate tax. So currently, when I die, no matter who would pay the income tax on the earnings of that trust is not includable in my estate. Well, Congress is considering stating that if I was required to pay the income tax on the earnings of that trust, then that trust, even though I gave it away, is includable in my estate. What that means for clients right now, or will mean if they pass this law, is we're going to have to look at every single irrevocable trust that was ever created to determine who the taxpayer is and to determine if we need to make some change to that trust or how that trust operates or who the trustee of that trust is in order to make sure that trust will not be included in the creator of the trust's estate when they die. Finally, Congress is considering changing the amount you can give away each year without there being an imposition of a gift tax. That's called the annual exclusion. And currently, I can give $15,000 away to as many people as I want. There's no gift tax. It doesn't change how much I can give away when I die. It's just a freebie. Congress is considering changing the number of those annual exclusions you can give, or constricting how much you can give an annual exclusion gift into a trust, or some other way in order to, again, restrict how much American citizens can give away free of tax. There is a technique that we've used many times called a grantor retained annuity trust. And I'll give you an example of that. Let's say I own, again, Microsoft stock, and I think Microsoft stock is going to appreciate. And I don't need that appreciation, so I want to give it away to my kids now, but I don't want to have any gift tax. So I could create this trust called a Grantor Retained Annuity Trust, or GRAT for short. And that GRAT would say that I will receive back the Microsoft stock, the value of the Microsoft stock, plus the federal interest rate. So if I put $1 million into that trust, that means I would receive back about $1,100,000 over the next 2 years. Any appreciation is free of gift and estate tax. Congress is considering changing the rules for those type of trusts in a number of different ways, one of which is to say that the gift cannot be worth zero when you give it. It has to be worth at least $500,000 or 10% of the value of the assets going into the trust. So that would limit the usefulness of this trust, especially if Congress decides to lower the gift tax exemption. There is a proposal in Congress to lower the gift tax exemption to $1 million, even though the estate tax exemption would be $3.5 million or $6 million. If Congress does that, then the usefulness of GRATs will go away. As you can see, and as I've explained, these tax law changes have far-reaching implications for almost everyone. Now is the time to plan. Now is the time to talk to your financial advisor or your estate planning attorney. Or you can contact me, Gary Altman, at 301-468-3220, or you can email me at gary.altman@frosttaxlaw.com. I look forward to speaking with you and helping you with your estate planning needs. Thank you.